We're live on 2-3 Ghana on Facebook, DSTV channel 279, all across the world on 3news.com. We're starting off with the Supreme Court now. There's been a landmark ruling that's generated a lot of reactions. Portia.
Exactly, and the Supreme Court has unanimously ruled that deputy speakers of Parliament or any member of Parliament who presides over business of the House does not lose his or her right to vote. The ruling follows an application by private legal practitioner Justice Abdullahi, who prayed the Apex Court to declare as unconstitutional MP for Bekwai Joseph Osei-Wusu counting himself and voting for the processes of a quorum. Lord Idwasari sat through proceedings and reports.
The ruling by the 7-member panel, presided by Justice Jones Doche, confirmed the approval of the 2022 budget without NDC MPs' participation on November 30th, 2021.
The number presented to me by the clerks at table is 137 of you plus me, MP for Bekwai, 138.
The Supreme Court cited Article 1041, which says, except otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present, noting that the Bekwai MP exercised his constitutional right. The Apex Court also struck out Parliamentary Order 1093, which reads, a deputy speaker or any other member presiding shall not retain his original vote whilst presiding. Attorney General Godfrey Dame hailed the ruling by the Supreme Court.
In all jurisdictions around the world, whenever the Speaker of Parliament or a Deputy Speaker of Parliament is a member of Parliament, he always has the right to vote. In England, it's the same. In America, it's the same. In Australia, Canada, everywhere is the same. So the right to vote is actually linked to the right to represent his constituency. So are we saying that on account of the person being a deputy speaker, he loses the right to represent his people when a major issue of national importance has arisen?
Minority Leader Haruna Idrisu, reacting to the ruling, expressed utter disappointment.
Everywhere in the world, in civilized democracies, including the United Kingdom, the presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor custom vote. The Supreme Court, to put it aptly, this ruling is judicial support for e-levy, nothing more.
Lawyer Justice Abdullahi, who filed the case against the Attorney General, said he was not surprised by the ruling.
Because I think the Constitution wins, the people of Ghana win, and this is the best decision that I think we should have had. It puts clarity on the law, despite the fact that some of the reliefs that I was seeking were not obtained. But there's a far-reaching decision that has been made by the Supreme Court today, to the extent of striking out portions of the standing orders, and this is very good for all of us.
For TV3 News, Lord Idwasari, Accra.
Well, you recall the first instance that Joseph also tried to vote. It led to the Ashaman MP trying to snatch his seat as Speaker of Parliament and all the chaos that erupted in Parliament at the time. Well, the first Deputy Speaker of Parliament, Joseph Osei-Wusu, has actually hailed the Supreme Court judgment giving the green light for deputy speakers to vote while presiding over the business of the House. The minority had earlier described the judgment as a judicial support for the controversial e-levy. But speaking to the media, Joseph Osei-Wusu says the ruling of the Supreme Court has cleared all the controversy on his position to vote.
It was a voice vote, and I did not participate in the voice vote, but I insisted that I be counted as a member of Parliament present to constitute the quorum before a decision was taken. Indeed, this decision affirms that position that I took. I find that very refreshing. Soon after that decision, a former Speaker of Parliament called me and he said, I called you to congratulate you for being bold to take this decision, because that is how the frontiers of the law are expanded. Matters that have never arisen are now in the fore because of the numbers we have in the chambers. So anytime there's disagreement, as I've said already, I will interpret the rules and the law as I understand it. I encourage people who disagree with me to boldly state their position, and if need be, refer to the appropriate body like the Supreme Court to guide us. As of now, at the end of it all, we are being guided. What we have not done before, where the way was not clearly marked out by our own standing orders, have now been cleared by the Supreme Court, and I think it will help us advance our democracy and our practice in this chamber. I will just be counted as where I place my vote. There's no need for any getting up or anything. I vote here or here. Indeed, I've observed proceedings in the British Parliament and the American one. The person presiding will say, add my vote to ayes or noes. And I think that practice should suffice.
Well, Portia, this 8th Parliament never stops giving.
Exactly, and we have a reaction from the Member of Parliament for Ningo from Sam George. He has vowed to keep the sanctity of Parliament by ensuring that no Deputy Speaker casts his vote on the floor of Parliament, despite the Supreme Court ruling. He argued that the Supreme Court has no business directing how Parliament should conduct its businesses.
They have given their ruling. We have heard. But I believe that there's a reason why our standing orders say that Parliament is the master of its own affairs, and that the procedure in Parliament resides in the bosom of Mr. Speaker. For me, I cannot for the life of me be part of what I would deem an illegality, which would be that the person presiding in the House would take part in a vote he's pretending over. And so I do not know what position my leadership will take or my party will take, but my principled position is one that states that anyone presiding, be it Mr. Speaker or any of his 2 deputies, has absolutely no business taking part in the vote on the floor of the House. And we will employ every legal means within the parliamentary procedure to ensure that this long time tested practice of Parliament, which is 30 years old this year, will be upheld. Until the Lord Justices decide to start expunging parts of the Constitution, like 1045, for us to see that the application of the law is not skewed and imbalanced. I do not see why anyone who has a conflict of interest should be allowed to vote. Because 1045 says you have a conflict, do not vote. Why did the Lord Justices go silent on the standing orders of Parliament that say that a chairman of a committee does not have a vote? A chairman of a committee in Parliament does not have an original vote. So why are they not saying that that is also a deprivation of his constituents? I mean, we pray the Lord Justices. Their role is to bring clarity, but not rather lead us into confusion and obfuscate what the facts are. The law is clear. We have heard them. They've passed their ruling. But Parliament, we are masters of our own procedure. We will carry out what we believe is right on the floor.
It's going to be very interesting days ahead, as Sam George is stating that Parliament is a master of its own rules and procedures. And this Supreme Court ruling, how that is going to be executed in the business of the House is something to look out for. But you can go on to 3news.com, you'll get an extended version of all the stories on this particular landmark ruling as we had earlier today. So make some time and visit 3news.com. But one of the issues that's come up, Portia, is the order 1093, which was also struck out by the Supreme Court. That order 1093 of the Standing Orders of Parliament provides that a Deputy Speaker or any other Member of Parliament presiding over the business of the House shall not retain his or her original vote while presiding. On whether the ruling allows a Deputy Speaker to vote is an interference in Parliament's rules, the former Attorney General, Nia Ikweotu, does not think the Supreme Court ruling interferes with Parliament's work. Speaking on 3FM, Nia Ikweotu stated that the standing orders are an enactment and if inconsistent with the Constitution of the Republic of Ghana, can be struck out by the Supreme Court of the land?
Not at all. Article 1(2) of the Constitution reads, "This Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provisions of this Constitution shall, to the extent of the inconsistency, be void." So this is the supreme law. He went to court to say that that article is consistent with provisions of the Constitution. The Supreme Court has held that and that is in accordance with the 1(2). There is no other law in this country which is superior to the Constitution. So whether the Parliament is a matter of their own rules or not, all their rules are subject to this Constitution. The only others is an enactment. So if you find something in it which is inconsistent with the Supreme Law, the Constitution says go to the Supreme Court for interpretation, and once the Supreme Court declares that it is inconsistent with any provision of the Constitution, to that extent, that law becomes void. So when it is so unanimous and there is no fundamental error that has been committed by the court, it will be very difficult for you in a review